For an athlete competing on the global stage, the physical toll is absolute. Margins are measured in fractions of a second, and access to precise, immediate medical care dictates who stays on the track and whose career ends early. The 2013 Anti-Doping Act took the complex, highly specific world of sports medicine and classified doping allegations as actual criminal offenses, treating athletes exactly like standard criminal defendants. An athlete testing positive for a restricted asthma medication wouldn't face a medical board. They were pulled entirely out of the realm of sports science and dragged into the rigid, slow-moving standard criminal justice system. This created a massive legal logjam. Under previous political administrations, the bureaucracy stalled, leaving regulatory oversight opaque while cases piled up on judges' desks. The setup trapped athletes in legal limbo for years without specialized experts to hear their defense, while the public watched a sports administration operate with minimal accountability. In September 2025, a new piece of legislation hit the floor of Parliament. The Convention Against Doping in Sport Amendment Bill systematically dismantled the 2013 framework. Introduced by the new NPP government, the policy operates on a strict dual mandate: pull the athletes out of the criminal courts and simultaneously place the administrators under intense anti-corruption scrutiny. The state's focus has shifted. It protects the health and legal rights of the competitors on the field while heavily policing the executives managing the money. For a professional competitor, the most critical piece of medical paperwork is a TUE, a Therapeutic Use Exemption. It grants legitimate permission to take a restricted substance for a diagnosed health condition. If the administrative process to approve that exemption drags on, an athlete has to make an impossible choice: compete sick or take the necessary medicine and risk a total ban from their sport. Clauses 4 and 5 create a dedicated TUE committee. It requires a minimum of 3 members sourced from clinical, sports, and exercise medicine. The law also dictates speed. For in-competition substances, the committee must process applications as soon as possible, within a strict 30-day window. Medical decisions are now exclusively made by doctors operating on a mandated deadline. The athlete receives their required treatment, and the sport maintains a level playing field. When an athlete is actually accused of a violation, the process is now entirely different. Clause 3 explicitly repeals Part 1 of the original Act, officially stripping the standard high court of its jurisdiction over doping violations. Instead of facing a criminal judge, accused individuals go before a specialized tribunal known as the Disciplinary Panel, outlined in Clause 20. This panel is drawn from a highly specific pool of professionals: 2 lawyers with over 5 years of active court experience, 3 medical practitioners specialized in sports medicine, and 3 veteran sports administrators. If the athlete objects to the verdict, the law guarantees them the right to challenge the decision through an independent 6-member appeal panel. And for international-level competitors, the legislation cuts through local bureaucracy entirely, providing a direct legal pipeline to the ultimate global authority in Switzerland, the Court of Arbitration for Sport. Accused athletes are guaranteed a science-based defense, evaluated by industry experts, entirely free from the stigma and crushing delays of the standard justice system. While the athletes receive specialized protections, the general public requires assurance that the regulatory agency itself is immune to systemic corruption. The Board of Governors has been entirely restructured. To prevent isolated political manipulation, the board now requires ex officio members from the Ministry of Finance, the Attorney General's Department, and the Director General of Health Services. Clause 22 introduces a strict financial safeguard. The agency cannot accept any foreign grants, gifts, or donations without obtaining prior written approval from the Department of External Resources. Clause 23 introduces the most aggressive oversight mechanism. The Anti-Doping Agency is now a scheduled institution, bound directly to the Anti-Corruption Act of 2023. Furthermore, every agency employee is designated a public servant under the Penal Code, making them directly liable for graft. These clauses legally insulate taxpayer funds and transform a vulnerable sports body into a highly regulated public institution. Sri Lanka has traded a sluggish, criminalized bottleneck for a transparent, specialized administrative ecosystem. By implementing exact medical tribunals and independent appeal pathways, the nation aligns its domestic regulations fully with the World Anti-Doping Code. For the athletes, this provides the guarantee of rapid medical reviews, expert-led tribunals, and a commitment to safe, fair competition. For the public, it provides the assurance that the institutions managing national sports are transparent, closely monitored, and locked down by national anti-corruption laws. The 2025 amendment proves that elevating a nation to global sporting standards requires protecting the rights of the players on the field and fiercely guarding the trust of the citizens off it.